Welcome to The Explainer. Today, we're diving into a neighborhood dispute that all comes down to the interpretation of just a few words in a contract. It's a classic showdown, one homeowner versus their HOA, and it all hinges on a potential legal loophole. So this all starts with homeowner Shawna Townsend. She was convinced that the governing documents for her community, the CC&Rs, had this very specific wording that gave her the right to park her vehicle in her driveway, even though the HOA was telling her absolutely not. Okay, so to really get what she was arguing, we have to look at the vehicle at the heart of all this. Because believe me, the terminology here is everything. Now, this difference you're looking at, it is absolutely critical. On the left, you've got a truck camper. That's what Miss Townsend owned. But here's where things get messy. The HOA's own violation notices kept adding to the confusion, sometimes calling her vehicle a trailer or a camper shell. Townsend, however, was super clear about what she had. And while this one notice kicked off a whole year-long battle, you see, the HOA saw a prohibited vehicle, but Mrs. Townsend looked at that very same rulebook and believed it was 100% on her side. All right, so let's dig into how Miss Townsend actually built her case. I mean, she went at this with almost surgical precision, focusing on the exact words in the HOA's own documents. Her whole argument was pretty simple and honestly kind of brilliant. The rules specifically ban unmounted camper units. And since her camper was always mounted on her truck, she argued that rule just didn't apply to her. Period. And she didn't stop there. She kept digging and found even more ammo in the community guidelines. They prohibited a detached camper. And again, she's pointing out, hey, mine's always attached. So in her mind, that rule shouldn't apply either. So this brings us to the big question at the heart of her whole challenge, right? If a camper is always mounted and always attached, is it actually allowed? You see, she wasn't arguing about the spirit of the law, she was going straight for the letter of the law. If the rules don't explicitly prohibit an attached mounted camper, then it must be permitted. Okay, so that's her side. Now let's flip the script and look at the HOA's position. Because for them, this wasn't about a couple of little words, it was about the bigger picture, the overall intent of the rules. And this whole thing just dragged on for months. As you can see, the HOA kept sending notices, Ms. Townsend would appeal, and then she'd get denied. This timeline really just shows you that neither side was even thinking about backing down. So the HOA's entire argument really hung on this one little catch-all phrase at the end of the list. They basically said, look, that phrase is there for a reason. They claimed it was put there to cover exactly this kind of situation, making the debate over attached or detached totally irrelevant. In their eyes, her camper was clearly similar equipment. And to back this up, the HOA pulled out a document from all the way back in 2000 that defined this really broad category of recreational-type vehicles. And guess what was on that list? Yep, campers. And there it is again, that all-important catch-all phrase, others similar equipment, which they argued Townsend's vehicle fit right into. So you can see the two sides are just miles apart. And it all finally came to a head at an administrative hearing on January 19, 2023. This was it, the moment where both arguments were going to be put to the test in front of a judge. At the hearing, Ms. Townsend really doubled down, making it crystal clear that her entire case, the whole thing, hung on that one single word, detached. But, the judge immediately zeroed in on the HOA's key counterargument. Right out of the gate, she was honing in on that catch-all phrase, which was a big signal that the broader context of the rule was going to be really important here. And that led to this really critical moment in the hearing. When asked directly, Ms. Townsend had to agree that, yeah, her vehicle was a camper. And under the HOA's broad definition, campers were explicitly listed as prohibited recreational-type vehicles. This was the moment her very specific argument collided with the HOA's much broader rule. So the big question is, after hearing both sides, the precise word-for-word argument and the broad intent-based argument, how did the judge rule? And wow, this one line from the final decision pretty much says it all. The judge concluded that the clever loophole was ultimately a word game. Yeah, the judge's decision just systematically took that loophole argument apart. As you can see here, the ruling found that the specific words Ms. Townsend relied on were overridden by the much broader other similar equipment clause, and that her truck camper was indeed a prohibited recreational type vehicle. And just like that, the case was closed.
The petition was dismissed, and the HOA's violation notice was upheld. In the end, the homeowner's clever interpretation of the rules just wasn't enough to win the day.
You know, this case leaves us with a really fascinating question that applies far beyond just HOAs. In any contract or set of rules, when there's some ambiguity, what should win out? The literal, specific text on the page, or the overall spirit and intent? This dispute shows that sometimes a clever loophole just isn't enough.